probably need to look at dates within speedy trial if we're going to set this. Is that your understanding?
Yes, Your Honor, it is. Thank you.
Okay. So we need to look at a trial that would start sometime by December 9th in order to comply with Idaho's speedy trial requirements under the Constitution in 1935-01. So how many days do you anticipate you'll need to try the case, Ms. Blake?
Your Honor, given the nature of the charges and the number of the charges in this case, the state is anticipating approximately 5 weeks for a trial in this matter.
All right, Mr. Pryor, if the state's going to request 5 weeks, what are your thoughts on that time frame and anticipation of what your defense may take as well?
Judge, I concur with Ms. Blake. I anticipate a 5 or 6 week trial.
All right, let me get to the calendar here. It's not the most convenient month for it because of holidays, but I think we're probably looking at November. Apologies for the delay here. I'm just looking at my calendar and other things I've got scheduled. We could start the trial on November 8th. And then that'd put us out to, we're looking at 5 full weeks, December 10th.
That's available to the defense, Judge.
That will also work for the state, Your Honor.
All right, we'll set trial then November 8th to December 10th. And let me ask counsel if you think we ought to have the trial scheduled out for the following week, because there's a judicial holiday on the 11th of November and then again on the 25th. So we lose 2 full days there.
I would request that, Judge. I think that would be prudent.
The state would agree that that would be appropriate, Your Honor. I think it's better to hold those dates than not have them available.
Very well. We'll set the trial to conclude then by December 17th. Let's schedule a pretrial conference. I want to go more than a month in advance because of the length of that trial. So about September 29 for a pretrial conference. If that date's available, we could do that at 9:30 a.m.
That works for the defense, Judge. Thank you.
That will work for the state as well, Your Honor. Thank you.
All right, we'll send out our notice of trial setting. That'll contain your deadlines for certain things. Discovery cutoff, expert witness disclosures, et cetera, will be included in the court scheduling order. We don't have anything else scheduled for hearing today. I would note Mr. Pryor filed a motion to extend deadlines for a 12B6 motion. I thought it might be worth asking whether or not there's going to be any objection to that. You know, Ms. Blake, are you prepared to discuss that today?
Yes, Your Honor, I'm prepared to discuss that. The state was intending to file a notice of non-opposition. I think given the nature of the request that Mr. Pryor is waiting on discovery due to the voluminous amount of discovery in this case, he'll need time to review that, and the state recognizes that. So I believe it is an appropriate request, and we would have no objection.
Thank you, Ms. Blake. Judge, one of the reasons for the request was that Mr. Wood and Ms. Blake and I discussed that they are going to resubmit all of the discovery from the other case Mr. DAYBELL's involved in as a whole. They're going to resubmit everything to me, and I made that specific request, and they've agreed to oblige me with all of the discovery from everything so that I have a complete set to once again go through and review. And I appreciate Ms. Blake and Mr. Wood accommodating that. They did put in their disclosure. I thought that was a little unusual, but they put in their disclosure that they will provide me everything by the 15th of July. And given the fact that there was voluminous discovery, I understand Ms. Blake's need for additional time on that, and I understand that. And at this point, that was the basis for the extension. And once I get the discovery, Ms. Blake and I will have to talk about how we proceed from there. But as a matter of a lengthy explanation, Judge, that was the reason behind it. So,
all right, I'll grant the motion that it was filed on June 21st to extend deadlines for filing a motion under 12B of the criminal rules. In your proposed order, you've got still a deadline in there that's not filled in. So what are your thoughts on a reasonable deadline for the motions to be filed and heard?
Well, Judge, assuming that I get all of the evidence, and Judge, I don't know what occurred at the grand jury. I know there were 5 days of testimony. I imagine it's going to be voluminous. And I imagine the discovery is going to be, as it was before, voluminous. I expect that it's going to take me at least 30 days to get through everything. So from the 15th of July, assuming Ms. Blake's going to do that, and I did offer to Ms. Blake and Mr. Wood to hand deliver hard drives to them if it would expedite things. They declined that. They don't want me to do that. They said that they will provide me everything, and I appreciate that. But Judge, could I have 60 days from the 15th of July? Is that possible?
That puts us on a pretty tight time frame. That would put us at September 15th, then with a pretrial on September 29th. I mean, but it would be heard before pretrial conference. I'll get the state's input on that. Ms. Blake, thoughts on it?
Your Honor, sorry. I agree that it puts us on a pretty tight timeline. However, I am well aware of the voluminous amount of discovery. I do recognize that the grand jury transcript will be lengthy and require some time for Mr. Pryor to review that. So the state would not have an objection to that. Of course, what we'd ask is if at any point Mr. Pryor knows he's going to be filing that motion, if he just tries to get it filed as quickly as possible, or even confer with the state a little bit so that we don't delay the start of a trial in trying to determine any pretrial motions.
Okay. Based on that, what I'll do, Mr. Pryor, is I'll set at a few days before the 60, we'll have Friday, September 10th be the deadline listed in your order, and that's for the motion to be filed and heard. So obviously that would be really your deadline for a hearing date. Your motion would need to be filed in advance of the hearing date in order to allow response by the state.
Thank you, Your Honor.
All right. Any other matters we need to bring up this morning on the case?
Not from the defense, Your Honor. Thank you for your accommodation.
You're welcome. Ms. Blake?
Not from the state, Your Honor. Thank you.
Okay. Thank you. We'll get that scheduling order out. Have a good rest of your day, and we'll be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
This is the date and time for an initial appearance. Mr. Daybell, can you hear me okay?
Yes. Can you
I
hear
need
me?
you to speak a little bit louder, Mr. Daybell.
Yes, I can hear you.
Speak a little bit louder, Mr. Daybell.